All rise. The Court of Appeals, Division 1 is now in session.
Thank you, folks. Have a seat. All right, and good morning. If you folks are comfortable, you're welcome to remove your masks for the argument. We are here for oral argument and 1 CA CR 20-0088 State v. Khorrami. As you may know, we record and live stream the proceedings, so please give your name and the name of your client before you begin. According to current protocol, you will continue to argue from the council table. You do have a maximum of 20 minutes per side, although you are not required to use the entire 20 minutes. We do require you to keep track of your own time. The clock on the podium from when you're standing should be visible, but if you have any trouble seeing that clock, please feel free to move around the courtroom so that you can see it to make sure. I'll also try and give you guideposts just in case you're not seeing it, since it's not right in front of you the way it normally would be. We recognize, so what I'd like to do then is please keep in mind that we have read all the briefing. We have gone through the case very carefully. We have conferenced it before today's oral argument. And with that, counsel, you may proceed.
Thank you, Your Honor. My name is Ben Coleman. With me at council table is Bruce Samuels. We represent appellant Ray Khorrami. My tentative plan was to first discuss the sufficiency and the jury instruction claims together, and then discuss the Sixth Amendment claim regarding the 8-person jury. But obviously, I will answer any questions on any of the issues in any order that the court desires. Beginning with the sufficiency and jury instruction claim, I do want to start off with the elements of the offense, because the parties do have a dispute about the elements of the offense. It's our position that the fraudulent scheme statute has a materiality element. The state disagrees. It's our position that the United States Supreme Court's decision in Nda versus United States held that the language in both the federal and the Arizona fraud statutes, the common law language, a scheme or artifice to defraud, includes a materiality element. That was a unanimous, as to that issue, the Supreme Court was unanimous in opinion by Chief Justice Rehnquist. And the Arizona courts have held that the Arizona fraudulent scheme statute is designed after the federal fraud statute, and that federal cases are instructive. So we would urge the court to follow Nda and a long list of federal cases that hold that there is a materiality element to the fraudulent scheme statute.
In what regard and at what level?
Right, and we believe that the cases say that it is a reasonable person standard, a reasonably prudent.
So what do we do with the 35 years of precedent under Schneider that says it's just actual?
Well, Schneider discussed the misrepresentation statute, and right now I was focusing on fraudulent schemes. But getting to the misrepresentation statute, it's our position that Schneider held that there isn't a reasonable person standard, and I agree with Your Honor about that. However, the defendant in Schneider did not make the argument that there is a lesser standard called justifiable reliance. And in both Arizona cases, subsequent Arizona cases, and the U.S. Supreme Court in Field versus Manns after Schneider said that for misrepresentation statutes, most statutes don't require reasonable reliance. Most statutes don't require just actual reliance. The overwhelming majority view is that there's an intermediate level of reliance called justifiable reliance. And so for that statute, we're asking the court to adopt what the U.S. Supreme Court said in Field versus Manns, that there is a justifiable reliance standard as to that statute.
Okay, and I apologize, I did switch gears on you, but the Arizona statute also makes it clear that that's not even required, doesn't it?
For the misrepresentation statute?
Right.
I don't believe so. I believe the misrepresentation statute, it's clear that some form of reliance is required. And then the question is it just actual reliance, or is it this justifiable reliance standard? In our position is that after Schneider, both the U.S. Supreme Court and Arizona cases have said it's justifiable reliance. It doesn't have to be reasonable reliance, but justifiable reliance.
What Arizona case says justifiable?
We cited them in our briefs, and I can point the court to them, if you just give me a moment. They were civil cases, but I believe that they are...
Right, and we're dealing with the criminal statute and interpreting it. What criminal case says justifiable reliance?
There is no criminal Arizona case, but our position is that the U.S. Supreme Court said that the overwhelming view and the majority standard is a justifiable reliance standard, and I don't think Schneider addressed the lesser justifiable reliance standard. It only addressed a reasonable reliance standard.
So going back to the fraud statute, fraudulent schemes, why don't we just follow the plain language of the statute?
Well, we believe the plain language of the statute does indicate a materiality standard in two respects. The first is that the plain language of the statute uses the common law language, a scheme or artifice to defraud. And what the U.S. Supreme Court said is that common law language includes a materiality standard. So we don't think we're departing from the plain language. I know that the state has argued that with respect to omissions, there's this specific inclusion of the word material in front of omissions. And I believe why that was done is because an omissions theory of fraud is not as well rooted in the common law. So to make clear that not just common law fraud, which is a scheme or artifice to defraud, but also omissions and material omissions, to make it clear that materiality is required throughout the statute.
But that isn't the way we read statutes in Arizona. And when we look at statutes in Arizona, under the canons we look at, if you have some sort of defining term, it applies to the one that follows it, not in reverse. We don't back it up. The legislature usually could have said material preceding all of them. It didn't. So don't we read something into that?
Well, I also believe under Arizona law that Arizona courts do read common law language as incorporating the elements of the common law. And in this case, the common law language, scheme or artifice to defraud.
But when we start with statute, we start with the statutory construction guidelines. And the legislature tells us what to do with these criminal statutes. And the legislature said that it's a material omission, but it didn't say material as to the other portions.
Correct, and we believe that the reason why they didn't do that is because material is inherent in the common law language, scheme or artifice.
Anything more than your belief to follow that?
The U.S. Supreme Court in Nda versus United States said that exact same language includes a materiality element.
Where the legislature had made clear one thing was going to be material but didn't make it clear on the others, the Supreme Court has said that? In other words, they didn't interpret our language.
Well, no, obviously the Supreme Court was interpreting the federal statute, but we also believe that Arizona cases say that that federal precedent is instructive because the Arizona statute is modeled after the federal fraud statute, and therefore federal cases, particularly a unanimous opinion from the U.S. Supreme Court, would be instructive in that regard.
Counsel, do you have any case, or what's your best case for that interpretation, that the placement of the word material before omissions isn't of any great significance or larger significance, that materiality is required for those earlier elements of the statute?
Well, as far as, I don't know that there's any case that specifically addresses that materiality language in this particular statute. I don't know that I have a case that says you would look at that material language and, as to the words preceding it. However, I do think that when you have common law language in the statute.
Well, I'm looking for an omission, a criminal case with an omission and the word materiality in the statute being used once, and that is preceding the word omission. And I'm looking for a case, whether it's interpreting this statute or more generally, that says actually it's retro, in the context of that sentence, it looks backwards and modifies everything that comes before.
And I don't have a case that says that, but that's not my argument. My argument is that it would have been superfluous or redundant to include the materiality language earlier because...
Well, counsel, then it wasn't superfluous to include omission because there are certainly cases out there on common law regarding omission. And they existed when the statute was written. So your argument is there just weren't enough? That the legislature decided it had to make it clear for omission because it didn't think there were enough common law cases on material omissions? Well,
I think the argument is that the legislature felt that it was clear when it used the common law language, scheme or artifice to defraud, that...
And somehow it wasn't clear when it would have said omission.
Well, they evidently tacked on omissions later because if they felt that omissions was part of the common law concept, they wouldn't have felt that they had to repeat omissions again. I mean,
And that's your speculation, basically, on why they included the word omission there, or material.
Well, I think it's all speculation. I mean, no one has pointed to any specific legislative history that has said,
But when we look at statutes, we don't speculate, we read the words. And if you don't have, if you say the word is somehow ambiguous, then you have to have something more than just a speculation on why
But what's
they
the
did it.
ambiguity, right? I mean, if a statute, it might not be what the statute you want it to be, but if it's plain, if it's clear, that's how, we're not the legislature, we just interpret the words. Now, if it's ambiguous, then we can look to statutory history, construction, the dictionary, but how do we even get there?
I don't think you have to get there because I think the language is clear. It's a common law term, scheme or artifice to defraud. That term for centuries has included a materiality element. And so I don't think the language is ambiguous. I think, and the Supreme Court, U.S. Supreme Court found that. They said that this language is clear. It requires materiality.
In a civil or criminal or?
Criminal.
And it's our statute mirrors that statute, you said?
Yes, the Arizona cases say that the Arizona fraudulent scheme statute is designed after the federal fraud statute and that the federal cases are instructive in interpreting it.
And so what's this, let's play this out. What's the significance of that? Let's say it does say material and, looking over its shoulder. What's the significance of
Right.
that?
In this particular case, it's our position that a reasonably prudent person could not cannot enter into a deal and rely on a promise to conceal criminal activity. That there's no, you can't justifiably rely on that. It's against public policy.
As a matter of law.
As a matter of law.
And so that wasn't for the jury to decide.
I'm sorry, go ahead.
Well, I think it's both. I think this court, as a matter of law, can say that such a representation is immaterial as a matter of law. Obviously, the jury also you have a right to a jury determination on
It's
that.
immaterial because it's illegal?
Correct. And you can't justifiably rely on an illegal agreement.
So let's say this pipeline thing where they extorted this money and the money was paid in Bitcoin, I think. Are you familiar with that just in recent weeks?
I'm not, Your Honor.
Okay. So any illegal contract in your mind falls outside the four corners of this statute.
Well, so I don't know if the court has to go that broad, but I think that a contract to conceal criminal activity is relying on that is against public policy, it's against the law, and you can't either objectively, reasonably rely on that, or even justifiably rely on such
But
a...
you can actually rely on it.
You can
That's what
actually...
Schneider said.
You can actually rely on it. I mean...
So under your argument, is it that, and we're talking public policy now, that the only people this statute is going to protect are reasonable people and that the most vulnerable of our citizens, because they might act in a way that other people might not judge as reasonable, but actually rely, they're not going to be protected under this?
Well, I'm asking for a limited ruling that people who engage in criminal activity can't rely on agreements to conceal their criminal activity. I'm not... in justifiable reliance with respect to that statute.
There's the Lee case. I'm going back to 1914, and the Lee case says...
Well, that's extortion.
But it's still an illegal contract. And we don't say that just because there's an illegality that two wrongs will make a right, or three or four wrongs will make a right. So why wouldn't we do that?
Well, they may have been able to proceed under extortion here. They didn't. And I'm asking for the court not to interpret the fraud statute so broadly that then it absurdly applies. Victims of sexual assault, if they enter into an NDA promising that they won't disclose the sexual assault, presumably if this interpretation holds, they could be prosecuted for fraud if they later go to the authorities and disclose the sexual assault. I don't think the legislator intended that. It's the same thing as hypotheticals.
Well, it would only be a fraud if at the time they entered into it, they also intended not to follow through on it.
Correct.
Okay, so there is an additional piece to this.
Right.
So you can't really use that as an example unless you're going to say they intended at all times from the very beginning.
Right, I don't think the legislator would have intended for a victim of sexual assault who enters into an NDA knowing that they're later going to disclose the sexual assault to authorities, that they would have imagined that they could be prosecuted for fraud.
And I guess that's relevant here because, I mean, you keep saying you want a narrow decision, but now we're moving into victims of sexual assault.
The narrow decision that I'm asking is that people cannot engage in agreements to hide their criminal behavior and reasonably rely on those agreements because they're void. They're against public policy.
So is it, what statute? I mean, is there a statute or is that legal? That conduct that you just described? Can the legislature, if they wanted to, in their wisdom, can they make it illegal?
And they have in the compounding statute. The Arizona legislature has a compounding statute that says it's illegal to enter into these types of agreements. It's against, it's criminal.
So the problem is it wasn't prosecuted on a different statute, not so much, I guess you're talking about public policy within a fraud statute.
Exactly, Your Honor.
You're not contesting some larger.
Correct. They could have conceivably charged compounding. They didn't. They could have conceivably gone forward on extortion. The case didn't go forward on extortion. Those are potential avenues that they could have gone down. But that's not what occurred here. They're trying to expand the fraud statute into something that it's never been interpreted to do, which is to protect people who have engaged in criminal agreements. And that's the narrow ruling that we're asking.
Not to protect them, but to prosecute the other side where they committed it. It's no different than if two people enter into a drug deal and one gets shot, we prosecute the shooter. It doesn't matter that the victim was also engaging in criminal activity when it occurred.
Well,
So how is this different?
Well, I think it's different, and again, it comes down to the materiality element that we believe is in the fraud statute and the
I'm gonna
justifiable.
switch gears
Yes.
just momentarily, and I know you're at 4.5 minutes.
Yeah.
So very briefly, tell me why talk to me briefly about the opinion evidence regarding his intent.
Yes, Your Honor. The Ms. Agahi, the alleged victim in the case, testified that in her opinion, Mr. Khorrami never intended to keep this deal. And that's obviously the crucial intent requirement for promissory fraud. They had to prove that at the time he entered into the deal, that he never intended to keep it. So we think that was very important evidence, highly important evidence, and it was just inadmissible that, courts, we've cited a variety of federal cases which interpret the federal rules of evidence, and the Arizona rules are.
So let's assume it's error. Is it really reversible error? It was one statement made in the middle of a multi-day trial that wasn't the focus, even closing argument, that she said it. It was just a statement.
Well, I believe it was prejudicial in the sense that it goes right to the heart of the critical intent element, and I don't think that the evidence was overwhelming as to that intent element. He kept this secret.
Is that the test? Overwhelming?
I believe most courts say, well, look, if the evidence as to the intent was overwhelming, then
It's a fundamental error review.
I still believe that the prejudice standard is the same.
Well, the prejudice standard is there. I mean, but it doesn't, whether or not there's prejudice doesn't matter whether or not there's overwhelming evidence in the record or not. There's reasonable evidence.
I believe the standard is, could the jury have come to a different conclusion? And I believe that the answer is yes, that given the amount of time that he kept this secret, we're talking about 5 or 6 months, and that the jury could have concluded that he didn't have the requisite intent, and her opinion that he did have the requisite intent was prejudicial. I think the case was close in that regard, particularly as to the intent requirement.
Yeah, I think we're talking about maybe sufficiency of the evidence and evidentiary argument. Maybe we were passing it tonight, but that's.
Well, I don't believe, I agree, the tests are different. Sufficiency of the evidence is a different test than whether an evidentiary error was prejudicial. And I think the question is, was the evidence as to the intent so strong that this evidence that went right to it, that was inadmissible, that it was harmless? And it's our position that, given the closeness of the intent requirement, that it wasn't harmless in the case. We don't agree that it's a fundamental error standard. We think the objection was sufficient. But even if it is a fundamental error standard, we believe that still reversal would be appropriate. I just want to make one quick comment on the Sixth Amendment issue. the court is basically faced with three Supreme Court opinions. The first one, Thompson, from 1898, says that the federal Constitution requires a 12-person jury. Then in Williams around 1970, the Supreme Court said that, well, we're not going to follow Thompson and it doesn't require a 12-person jury. Most recently in Ramos, the Supreme Court overruled it reaffirmed Thompson and overruled all the essential reasoning in Williams. We gave the court supplemental authority that already a judge in Florida, which is just one of the 4 or 5 states that also doesn't require 12-person juries. He seems to think that Ramos overruled Williams and that a 12-person jury is required. And we would urge the court to follow the Supreme Court's opinion both in Thompson and in Ramos and find that that the 8-person jury in this case violated the Sixth Amendment.
Thank you.
Thank you. I'll save the little bit of time I have left.
Sure.
Thank you.
And counsel, if we don't mind starting in reverse order, just to address the Sixth Amendment briefly and also whether or not, assuming error, the opinion testimony was prejudicial.
Okay. Michelle Hogan with the Attorney General's Office for the state. I'll just turn to the evidentiary issue with the victim's testimony that she believed that the defendant never intended on remaining silent about the affair or keeping the agreement. Again, this was under fundamental error. There was no objection. And even assuming that there was some error, there could be no prejudice because, again, it was one statement. She had multiple days of testimony, so it was just a brief statement in her multi-day testimony. Also, the theory below wasn't that there was this contract. The defense theory below was that the victim had fabricated this entire agreement and the purpose of this money. They had presented evidence that the victim had received money from the defendant throughout their relationship, and maybe this $34,000 represented some sort of repayment, that this wasn't part of a contract that he intentionally breached. So it couldn't have been prejudicial to the defense because that wasn't their defense below. It was that she's not credible. You can't believe her about this $34,000. And then turning to the Sixth Amendment claim.
Let me ask you this, though,
Mhm.
because it was the state's theory. Isn't that establish some level of prejudice, possibly? Perhaps not reversible, but it was the state's theory there was a contract, and she made a statement as to the ultimate issue.
I mean, I'm not sure if it was a fraud theory. I'm not sure if they really called it a contract at trial. It was that he made a demand for money to remain silent, and he never intended to remain silent about this affair at the time he made the demand. So I don't know if they presented it as a contract, but
When did he have to have the intent?
The state,
From the state's perspective, did he have to have it at the moment they had the discussion, or could he form that intent later?
the state's theory below and here on appeal is that he had to have the intent when he entered the agreement, that he would never fulfill this demand that for money that he would remain silent. Otherwise, you'd be maybe looking at some sort of civil contract issue. But what makes it criminal is that he never intended to follow through with remaining silent.
That seems like an ultimate issue right there, that she's opining, she's trying to get into his head and say what he was thinking. How is that proper?
Well, I believe the purpose of getting that statement out was that there's all this evidence now that he never intended to keep this agreement. The way he treated her prior, he had become so obsessed and resentful of her, the discussions about the $30,000 or $34,000, how she was going to pay that. He kept going back and forth, moving deadlines, and then the post-promise actions, the adding additional requirements that she FaceTime him all the time. Now she's reflecting, hindsight, it's obvious that this was never going to be followed through. I just think that's what was the purpose. So it wasn't error in that sense because
That was what the jury was there to decide.
Right.
Was whether or not it was, and how did we make her the ninth person on this jury to offer that thought?
Well, I mean, I think that it just seems so obvious now, and she was just opining that, okay, hindsight, I I don't believe this. But I mean,
So
what
isn't that
what is
really good that it wasn't prejudicial? That it's no great surprise that she thought that.
right?
And it just doesn't really change the outcome.
That's it would go to the prejudice, that there just couldn't be
It-
prejudice from it.
And in that regard, isn't this really the reposturing that has occurred a bit, an effort to reweigh what the jury was deciding? And
Yes.
try and reweigh the evidence?
That's what the state argument is, and that when we're talking especially about sufficiency of the evidence, basically appellants asking this court to reweigh the entire evidence at the trial against this defense theory, this contract theory that they're presenting on appeal. That was, again, never presented below. And if you look at the sufficiency of the evidence claim, again, it was the state's theory and argument that the defendant had the intent not to follow through with this agreement from the very beginning. They've presented text messages showing how mad, resentful the defendant was of the victim and her relationship with her husband, and not following through with, I guess, the relationship with him. And I think sufficient evidence for a jury to make that determination was presented below that he never intended.
Counsel, let me ask you a question. Are you aware, either in representing the state, or maybe you can give us a site, where you have a case with similar facts that was prosecuted under the fraud statute rather than the extortion statute, and what happened?
I can't give any specific examples that I found over the extortion statute, but I did think of an example of where we would still charge someone with either fraud schemes or theft by extortion, was if, for example, the defendant had gone to a person and he had witnessed a murder, someone else witnessed a murder, and demanded money in exchange for silence, never intending to remain silent about it. I don't understand why that wouldn't be prosecutable just as here, because I know they're trying to make this argument that because it was covering or concealing up adultery.
Right, what I'm asking is
Yeah.
something more
Yeah.
practical, which is this always done? When you throw in extortion, do you also throw in this, not you, but the prosecution, this statute as sort of belt and suspenders?
I haven't seen it necessarily accompany the theft charges. I used to prosecute fraud schemes before, and I had never charged the two together, and I haven't seen many examples of it charged together. And it could be because the trial court has been finding this theft by extortion statute unconstitutional, that now the state has found other charges that would fit the fact pattern.
So why didn't the state cross appeal the constitutional ruling on the extortion statute?
This is more of a supposition, but is that because the state believed it could proceed on the fraud schemes and theft by material misrepresentation charges, that it wasn't worth the effort to, I guess, either cross appeal or special act. I mean, I guess because the charges were dismissed with prejudice, you might want a special action, the trial court's decision on the constitutionality of the theft by extortion statute. So because there were other charges available and this conduct fits within those charges, the state just proceeded on those.
If we could jump just briefly to the Sixth Amendment, wasn't Ramos really about a unanimous verdict case, not a size of the jury case?
Correct. It specifically overturned Johnson, and it's a companion case, and said it was overturning those cases that permitted the states to continue with unanimous or non-unanimous jury. Overturned those cases specifically. It said it in the language of the decision. So I just don't think that case can be read to have this implicit hidden meaning that it also overturned the not less or not fewer than 6-person juries requirement that it had stated in Williams, and then again reaffirmed in I think it's Ballo versus Georgia. So in those two cases, it's clear that a 12-person jury requirement is not applied to the states. Our statute permits 8-person juries for crimes that don't face 30 years or more in our criminal courts. So I think that would be an expansion of of the reading of Ramos to say that it also overturned Williams and the other case, as well as that there's no precedent now interpreting Ramos in the way that defense counsel has presented. And just briefly, I don't think there's a material requirement for the fraudulent schemes statute for misrepresentations. In our case law in Haas, which is a 1983 case, when it was describing the elements of the former statute, our fraud scheme statute, which is very similar to our current fraud scheme statute, it said that the statute or crime can be proven by active misrepresentations or omitting material facts. And it's clear from the case law and the history that the legislature applied material to omissions because they didn't want someone to be prosecuted for leaving out an inconsequential fact. It has to be something consequential to the fraud. And in our fraud scheme statute specifically, we have 2310B, where it makes clear that reliance is not even required for a fraud scheme statute. So I don't understand how we could also have this underlying justifiable reliance. I believe counsel was making an argument that justifiable reliance applies both to the fraud schemes and theft by material misrepresentation. And then Schneider says that and rejected an argument that there anything but actual reliance is required for that statute. And our fraud scheme statute says that reliance is not even an element of fraud schemes. And going to one more example that the appellant gave is the Nda Agreement. And I agree with this court that for someone to be prosecuted for a fraud scheme for entering in a Nda Agreement and then breaking that Nda Agreement, there would have to be a situation where the person entering the agreement actually kind of manufactured the situation and entered the agreement with the intent to break it, knowing all along, maybe the next day or a couple months later, they're going to break this NDA for a settlement. You know, they receive some sort of settlement in a sexual assault case and then subsequently break that NDA. So I just don't think it applies to this.
And let's just take that, though. That would be a violation of this statute. Let's say you've already got the book deal and you're working on the book, and you're entering the NDA while you're working on the book. That would be a violation of this statute.
Yes, the state would have to have sufficient proof that when the person,
Correct. Assuming
entered.
you prove that.
Yes, I mean, that's, I believe, a difficult standard in most situations so that these civil contracts aren't all of a sudden going to become fraud schemes because there has to be proof beyond a reasonable doubt that the victim or, the victim entered the contract, the defendant entered the contract knowing the defendant was going to break that contract all along.
Let me ask you this.
Mm-hmm.
Sorry, did you have something? Because it has to be at the beginning, and because it has to be something that was part of the scheme from the beginning, what do we do with the last words of the prosecutor in closing argument? Whether it was the first, the second, the third. How do we deal with that? Because it doesn't seem accurate.
It was, I could see how that could be interpreted more as, how can you believe, if you don't believe this first statement, I'll remain silent for $30,000. If you don't believe that, look at how he put these other lies forth and showing all his post-promise actions that showed that he had been lying about remaining silent the entire time. I know she kind of parsed each one out, that you could find that this one's a misrepresentation, this one's a misrepresentation. But when you look at the state's opening and first close and their theory throughout trial, it was that first $30,000 was exchanged for silence and he never intended that, and that these post-promise actions supported that he never intended to remain silent in the first instance.
So that it was just never a deviation from the idea that it had to be at the beginning. It was just, when you look at the evidence, stack up the evidence, you can see he never intended it from the beginning.
Correct. I believe the rebuttal was piling on all the lies to show that you couldn't believe that he ever intended to remain silent and when he entered the agreement.
And I guess then in that regard, it comes back to the jury got to look at all and decide whether or not from the beginning he ever intended to keep the promise.
Yes, and that was a jury question, and for sufficiency of the evidence, it's just, if at minimum, a reasonable juror could disagree, and I think there was sufficient evidence to at least meet that standard, if not more, that the defendant never intended to keep this agreement. There are no further questions. The state asks that you affirm the defendant's convictions, and thanks for your time.
Making sure we stop the clock. Counsel?
I just want to discuss the opinion testimony. I think the state just recognized that it's a difficult burden to show that the person had the intent from the very beginning. That they said it's very difficult for them to do. The victim in this case, not only did she give the improper opinion testimony, but the state dressed her up as an expert, or at least a quasi-expert, saying, you have all this experience in contract formation. What did you believe based on all your experience? What was his intent? So when you look at that, and you look at the fact, they still today, I don't believe, have produced an overwhelming case. They don't have the book deal. He's already signed the book deal at the beginning. They don't have anything like that. He kept the secret. It'd be one thing if he divulged the secret 2 days after they entered into the agreement. He kept a secret for 5 or 6 months and didn't disclose it until after she had breached all her promises and had actually disclosed the adultery to her own husband. Given that state of the evidence, this inadmissible evidence as to the critical mens rea element was prejudicial, and we'd ask the court to reverse both counts. Thank you.
Counsel. All right, we will take the case under advisement. We thank you folks for your arguments. We will issue our decision in due course, and we are going to stand in recess then. I don't believe we have any further arguments, so nothing to set up.